So we have mum and dad, Ronald Pump and Melody Pump. We are looking at the Pump family here. Ronald and Melody are the business owners and directors, mum and dad, and they have 3 children. They have Joe and his wife Jill down at the bottom there. Joe works full-time in the business, and his wife doesn't work. He's stay-at-home mom, looking after the children. We've then got Yvonne and Yusuf. Yvonne is the daughter of Ronald and Melody, and she does not work in the business. She's a teacher, so does not have any ongoing role in the business. And then you've got Eric and Simon and their dog, Major Champ. And Simon here is the son of Ronald and Melody. Again, no involvement in the business. Over to you, Anita.
Thank you, Charlotte. Good afternoon, everybody. We've got a slide here where Mr. and Mrs. Pump's daughter, Yvonne, has fallen in love with a Turkish national, Yusuf. They have a wedding planned for the 14th of February 2021. And Mr. and Mrs. Pump are concerned that the romance might be motivated by immigration status or financial issues. And this is actually a scenario that the family law team here have come across, not the exact scenario, but very similar scenarios on a regular basis. Yusuf is currently on a visitor's visa. Yvonne doesn't work in the business, as Dawn rightly said. She is a head teacher. She has her own home, no children, and is on a decent salary. Mr. and Mrs. Pump want to talk to their daughter Yvonne about this. What should they do? Now, the first thing is important to have this conversation prior to any shares being transferred to Yvonne, if that's what they choose to do. And the main consideration and protection here would be in the form of a prenuptial agreement. And prenuptial agreements get mixed press, I think, it's fair to say. It's a very difficult topic. People think that it is unromantic, but in reality, divorce happens to a great deal of the population, and it is an insurance. One thing we always say to our clients in the family law team is that a prenuptial agreement won't ever come into place whilst a couple are happily married. It will only come into the place in the event of separation. Therefore, there isn't anything unromantic about that, because if couples are going to stay happily married, the agreement will never ever have to be relied upon. Robert will know this. A lot of advisors spend a great deal of time advising their clients about avoiding tax. Divorce, one could argue, is a 50% tax if it ever happens. There are 3 elements to prenuptial agreements, and those are that the agreement has to be entered into 21 days before a marriage. There has to be financial disclosure. So Yusuf hasn't got much in the way of finances, but Yvonne would have to disclose her financial position to him, and he would have to do the same to her, so that they've both got full knowledge of their respective financial circumstances. Both parties also have to take independent legal advice. And in this scenario, Yusuf hasn't got the money to see a solicitor, and it would be sensible advice for Yvonne to pay for him to see an independent lawyer, so that obligation is satisfied. There's been lots and lots of high court cases in respect of prenuptial agreements. The leading case involves a French banker who gave up his job to go to study back at Oxford University. And it was his decision. The wife was from a very wealthy family. They entered into a prenuptial agreement that basically stated that the wife's assets would remain her own insofar as they came from her family. The wife then had significant assets transferred to her from her family, and the prenuptial agreement was upheld when the parties divorced, so that the husband was not able to attack the family finances. And in this scenario, what Mr. and Mrs. Pump will want to achieve is that Yusuf can't there can't be a situation where, say, Yvonne and Yusuf separate in 3-4 years' time, and Yusuf has a significant claim over the business, because once, as everyone will know, once the couple are married, the marital pot can comprise of any shares in business assets. And as I say, it can be a very difficult conversation. But if Yvonne was sitting before me, I would be saying to her, this is an insurance that your family are asking you to consider before you can benefit from the business. It is only an insurance. It is not going to come into play if you remain happily married. What we do say is that those sorts of agreements should be reviewed on events like children being born, because the court do have to consider that these type of agreements are fair. So it's not just that the three elements are satisfied: the financial disclosure, independent legal advice, and 21 days before the marriage. It's also that the overall arrangement is fair. But in these circumstances, if Yosef and Yvonne did not have children and they separated, say within 5 years, it would be quite fair to say that Yosef does not have any claim over Mr. and Mrs. Pump's business, or any part of that business that has been passed over to Yvonne by way of shareholding or otherwise. So that's just a whistle-stop tour of that scenario. I think we've got another family scenario that I can give some insight into. And this is Joe. So Joe is the son who you'll remember is working in the business tirelessly, full-time. And his wife, Jill, is traditionally in a role of homemaker. She doesn't work. Joe and Jill have got 2 children. Jill is, let's say she wears the trousers. So she is very upset that Joe is working tirelessly in the business for a modest salary, as Dawn touched upon. And although his family have been having some discussions about him having more control and more income, that has not yet happened. So Jill is very much of the view that Joe should be appointed as a director, and that he should hold the majority of the shares in the business. And Mr. and Mrs. Pump are concerned about that, because what they don't want is a situation where Jill has any control over the business. And they are also worried that Jill does seem extremely stressed at the moment, and this is causing, along with financial constraints and Joe's enhanced responsibility now that Mr. Pump is unwell, it's causing some arguments at home. So there are a few things that we can consider here. And one way of resolving it would be an agreement like a prenuptial agreement, but it's a postnuptial agreement. So the parties can enter into, so Jill and Joe enter into an agreement as to what would happen if they do separate. Now, this is a much more difficult conversation than a prenuptial agreement, because Joe and Jill are happily married. Why would he be wanting to enter into that sort of agreement now? Now, Joe could blame his parents, and he could say, well, my parents are thinking about their tax planning and their inheritance planning, and they need to put something in place to protect their position. But actually, I think in this scenario, looking at how, with Dawn, how Mr. and Mrs. Pump are actually going to transfer their shares, and being careful about that, is probably the most appropriate way forward. And thinking about the articles of association in terms of the business itself, making sure that any share transfers are appropriately drafted. And I know that Charlotte would be able to comment on that more than I can. And I do work with our corporate partners in scenarios like this, where we've got family businesses, and that this type of situation, if it did all go wrong and the marriage did break down, highlights the need for careful thought to be given in terms of how businesses are set up in terms of spouses, but also things like prenuptial agreements, because it's a much more easy conversation to be had prior to a marriage than once you're already married. because how do you then raise that once you're married? Some people will feel confident in doing that and saying it's an insurance document, like, you know, you have insurance for your home, your car, and this is just another thing that needs to be insured. But once you're actually married, I appreciate that's a much more difficult conversation. But we hope that they will sort it out. And going on to the third son here, so the second son, sorry. And this is Simon. And sadly, Simon and his partner, Eric, were a same-sex couple. And they have been married. So they have taken advantage of the gay marital law. So they are formally married. This is different to a civil partnership. If Simon and Eric were civil partners, the law is slightly different. There's a separate procedure. It's not a divorce. So we'll assume for these purposes that Simon and Eric are married. So exactly the same procedure as a heterosexual couple. They have a dog, Major Champ, and Simon has actually had an affair with a lady. So divorce is sadly on the cards. And Simon and Eric have taken advantage of the online divorce procedure, and they have already started that process. And most people who separate when they are married know that they need to get divorced and get on with it quite quickly in most circumstances. But there's a really common problem here in that I see many couples who have been divorced, but what they haven't done is resolved their finances into what's known as a consent order. And what that means is that there's been an order made and approved by the court that says that neither party can claim against the other in terms of their capital, income, property, pensions. And there's been many cases reported in the press where couples have fallen foul of this rule. They've been divorced, they haven't resolved their finances properly, and they haven't got the consent order. And many couples have agreed what should happen with the finances, and the family home has been sold and the money's been divided. But once one party, normally the weaker party, gets wind of the fact that they should have done the consent order, they can claim for more money. If the house has been sold, they can claim against the business, for instance. They can claim against pensions, income, if those claims have not been dismissed. There was a case which this firm was involved in, which involved a wealthy entrepreneur. And what happened in those circumstances was the wife came back 14 years later. 14 years previously, she'd only been entitled to a share of a modest former matrimonial home. 14 years later, the business had grown so much so it was worth millions of pounds, and the wife could make a claim. That is obviously a disaster scenario, but it's the same concept. And I have people time and time again come into my office and say, oh no, we've sorted the divorce and the house has been sold. And I'll say, well, have you got a consent order? Well, what's that? And they don't have one. And then we have a solicitor acting for a husband or a wife write a letter saying, well, actually, I am entitled to half of Mr. Jones's pension. And the pension hasn't been resolved because the consent order is the only way to dismiss all financial claims. So in this scenario, Joe and Simon need to make sure that they enter into a financial agreement. It's turned into a consent order by a firm of solicitors and it's sent to a court to approve. If that is not done, Eric could claim against Simon's shares in the business once any shares are transferred to him. So that needs to be done before Mr. and Mrs. Pump start thinking about whether they want to give Simon any shares or not. And again, a prenuptial agreement would have been helpful because everybody would know what was going to happen on separation. It's one less reason to fall out. And when I talk to people about prenuptial agreements, I often say, do you want a judge who you and your husband or wife don't know, making a decision about your finances and your children, when you have had no input in that, you're arguing in court and spending thousands of pounds on legal fees, when you could have had a conversation about what should happen on separation. And the way we deal with it, it's got to be dealt with delicately, because these couples who are entering into prenuptial arrangements are still together. So we're not having a big battle like we would if we needed to on a divorce, if things get very, very contentious. What we're doing is we're recommending normally another firm of solicitors who we trust. We're working with that firm, and we are entering into a process of negotiation and financial disclosure, treading extremely carefully, because this couple are still in a relationship. We're not dealing with a relationship breakdown here. In a situation where couples don't have a pre or post-nuptial agreement, and say Simon had already been transferred the shares, it can become messy and it can become expensive. And I'll work with my colleague. For instance, I've got a case at the moment where I'm working with my colleague Tom on in terms of how the business can run effectively when you've got a husband and a wife, for instance, who are co-directors. It's complex, it can become expensive. We need to think about resignations perhaps. And again, Charlotte will know all about that and what needs to happen. But I suppose my end message is that prevention is better than cure. Trying to deal with situations where you've got family members who are have spouses and they separate and they are both involved in the business is complex, messy and expensive. If parties think about situations where they are entering into agreements about what should happen on separation, it is far cheaper, cleaner, and it gives each person the ability to say what they think should happen rather than a stranger making a decision. So prevention better than cure is my message, which is actually a similar message to Dawn. If you leave these things too late, it can become extremely messy and expensive.